I had a lot of fun with this.
Certainly welcome. I'm glad all of you could join us on this Saturday morning. This is the Originalism and Property Rights session, and our panelists today will examine the extent to which the Constitution protects property rights. The Fifth Amendment provides that private property shall not be taken for public use without just compensation. What is the original meaning of this clause, and has the Supreme Court stayed true to it? Justice O'Connor, in her dissent in Kelo v. City of New London, didn't think so, nor did Justice Thomas in his dissent in Murr v. Wisconsin. And today, we're going to find out what our panelists think about this issue. Let me briefly provide you with a quick overview of the format that we're going to follow today, which is pretty standard. I'm going to briefly introduce our four panelists. Each will speak for about 6 to 8 minutes, and then they'll have a brief opportunity to respond to each other or ask each other questions, and then I'll open it up to the audience after that. Certainly the bios are in the app and on the website, so I'm just going to hit some of the highlights to keep this brief. Our first speaker will be Professor Ilya Somin. He's a law professor at George Mason, and his research focuses on constitutional law and property law. And interestingly, in 2009, he testified on property rights issues before the Senate Judiciary Committee before Justice Sotomayor's confirmation hearings. He writes regularly for the Volokh Conspiracy blog, which I'm sure a lot of Federalist Society members are familiar with, and he previously served as co-editor of the Supreme Court Economic Review. Our second speaker will be Professor Thomas Merrill, who is a professor at Columbia Law School. He previously taught at Northwestern Law and Yale Law School. He also served as deputy solicitor at the Department of Justice, and I can't even begin to list all of his writings about property rights, but you will find that in his bio. Our third speaker will be Professor Richard Lazarus. He's a professor at Harvard Law School, where he teaches environmental law, natural resources law, Supreme Court advocacy, and torts. He has represented the United States, state and local governments, and environmental groups in the Supreme Court in more than 40 cases, and has presented oral arguments in 14 of those, most recently and most interestingly for this panel, in Murr v. Wisconsin. He's also filed briefs on behalf of governmental parties in many other regulatory takings cases. And he will be publishing, this is also interesting to me, and I know to my former boss, Susan Dudley, who was the administrator of OIRA, when this decision came down from the Supreme Court, he's publishing a book on the Supreme Court's 2007 decision in Massachusetts v. EPA. He previously worked for the Solicitor General's office, where he was assistant to the Solicitor General. And last but certainly not least, Professor Eric Clays, who is a professor of law at Antonin Scalia Law School. He's written widely in the fields of property law, private law, and constitutional law, and his current research interests focus on natural rights justifications for property. His main teaching interests include property, torts, jurisprudence, and intellectual property. And with that, I will now turn to Professor Somin.
Thank you. I'd like to thank Federalist Society for organizing this event and all of you for coming. In my talk, I'm going to talk about the original meaning of public use, how it constrains the government and what it can take private property for, and what it might mean for today if we move closer back to that original meaning. So the Fifth Amendment indicates that the government can only take private property if it's for public use, but for over 200 years now, there has been an active debate about what exactly that means. One side of the debate, what I call the narrow view of public use, says that a public use only exists if it's for a government-owned facility, such as a public road, for example, or if the property is taken for a new private owner, that private owner must have a legal duty to serve the entire public or give them access, such as with a public utility, for example. The other view, the broad view of public use, holds that virtually anything can be a public use so long as there's some potential benefit to the public. And this is the view that has been embraced by the Supreme Court in such modern decisions as Kelo versus City of New London and Berman versus Parker. In my book, The Grasping Hand, which I'm going to draw on today, I argue for the narrow views on originalist grounds, also actually on living constitution grounds as well, but that's perhaps for a different panel. And I think the evidence does support that position. So I'll talk first about the evidence as of 1791 when the Bill of Rights was first ratified. And at that time, we have only limited information about not only public use, but really almost anything having to do with the Takings Clause. It was not one of the parts of the Bill of Rights that was particularly much debated at the time. However, such evidence as we do have supports mostly the narrow view of public use. If you look at some of these sources that the founders were heavily influenced by, like Blackstone, John Locke, and others, they all drew distinctions between takings for public projects, publicly owned ones, and takings for private parties, and considered the latter illegitimate and beyond the power of government. If you also look at early decisions such as Calder versus Bull and Van Horn Lessee, both written by Supreme Court justices, they also suggest that takings from one person to another are unconstitutional and impermissible. And there's a number of early state court decisions interpreting state public use clauses mostly in a narrow direction. Many originalists today argue that when it comes to applying the Bill of Rights to state and local governments, and those are governments that do the vast majority of condemnations, the right time period to look at is not 1791, but 1868. 1868, of course, is when the 14th Amendment was ratified and applied the Bill of Rights to the states. And for this period, we actually have a great deal of evidence. By that time, numerous state Supreme Courts had issued decisions interpreting the meaning of public use under their state constitutions, nearly all of which have wording very close to or identical to the federal constitution, and a large majority of those state Supreme Courts, approximately 2/3, actually ruled in favor of the narrow view of public use. The same position was adopted overwhelmingly by the leading legal treatises of this period, which dealt with the question of public use. And in the 1860s, people didn't have things like Westlaw and Lexis, so if you wanted to look up the meaning of legal terms, these treatises were far more important at that time than they are today. In addition, the narrow view of public use is much more consistent than the broad view, with the reason why the framers of the 14th Amendment and others at the time wanted to incorporate the Takings Clause against the states to begin with, which is that they wanted to protect the property rights of white unionists in the South and also recently freed African Americans. If the government can take property for virtually any reason it wants, as under the broad view of public use, then that provides very little meaningful protection for that purpose. Now, I will pause now to say that there are some people who go beyond the traditional narrow versus broad view of public use debate. There are a few modern scholars like Jed Rubenfeld from Yale and possibly Tom Merrill today. I'm not sure if he's actually going to make this argument, but just in case he is, I'm going to preempt it. And that is the argument that not only does the public use clause not constrain as much as the narrow view, but it doesn't constrain takings at all. It just sort of says if it's taken for a public use, then there must be compensation, but it doesn't say it must only be taken for a public use. I think this is linguistically possible, but it's just not in accordance with the original meaning. I already mentioned the evidence of the original meaning. I will just further add that in the entire 200-year history of this debate, I'm not aware of a single legal decision, either federal or state court, which actually has taken this sort of Jed Rubenfeld-like position. And while linguistically, I think this is a possible reading of the text. So is the view that there's an assumption there that takings must be for a public use, and that assumption is firmly embedded both in the original meaning and in the case law up to this point. So what if we were to go back to the original meaning of public use, as to my cards on the table I do advocate doing? I think this would lead to the reversal of the Kelo decision, the notorious 2005 case where the Supreme Court ruled that you can take property and give it to private parties just to promote economic development. I think it would also lead to what, to my mind, is the much worse decision in Berman versus Parker in 1954, which is the first decision where the Supreme Court endorsed the broad view of public use. That decision authorized blight and urban renewal condemnations and led to displacement of many hundreds of thousands of people, mostly poor and minorities, from their neighborhoods. So Berman versus Parker, I like to say, is the most important, terrible Supreme Court decision that even many law professors have never heard of, but they should hear of it, and we should talk about whether we really want to keep it or not. I think the answer is that it would be a good thing to get rid of, because abusive blight condemnations, while not as common today as in the 1950s and 60s, certainly still do happen on a considerable extent, and they still victimize the poor and disadvantaged, as is also true for economic development takings of the sort upheld in the Kelo case. Finally, I would mention that reversal of these precedents would have implications also for pipeline condemnations, which have become a big issue in recent years. In many states, it's possible to condemn property for pipelines, even though the pipeline is not a common carrier or a public utility of any kind, and these takings do sometimes harm large numbers of people, cause environmental damage, and the like. So I think, therefore, this is an area where the original meaning is significantly at variance with current doctrine, but I think it's possible to at least begin to bring current doctrine more in line with the original meaning, and overall the consequences of doing so, I think, would be quite beneficial, particularly for the poor and the politically weak, and those people who tend to get shafted when the government can take property for almost any reason that it wants. So on that note, I conclude, but I very much look forward to discussion. Thank you.
Thank you, Professor Merrill.
Okay, so I'm going to confine my comments to the original meaning of the Fifth Amendment's Takings Clause as of 1791 when it was adopted. Ilya alluded to this, but let me elaborate a little bit. We know very, very little about the original understanding of the Takings Clause as of 1791. As a condition of ratification of the main body of the Constitution, a number of states insisted that there be a Bill of Rights added to the Constitution, and as part of that discussion, over 80 states submitted over 80 proposed amendments to the first Congress for adoption as a Bill of Rights. Not a single state proposed adopting a takings clause as part of the original